Good morning, everyone. This is an oral argument on cross petitions of Edgar R. Page and PageOne Financial, Incorporated, and the Division of Enforcement as well, for review of the initial decision of an administrative law judge. A total of 40 minutes has been allowed for the argument, with 20 minutes allocated to each side. Respondents will argue first, and each side may reserve time for rebuttal. Mr. Haim, do you wish to reserve any time for rebuttal?
Yes, 3 minutes.
Very well. You may proceed.
Thank you, and good morning, members of the Commission. My name is Robert Haim, and I represent the respondents, Mr. Page and PageOne. This administrative proceeding concerns Edgar Page, an individual who has worked in the investment industry for approximately 39 years, and PageOne Financial Corporation, which has been a registered investment advisor since 1986. At the height of its assets under management, it had a little over $200 million in assets under management and approximately 10 employees that worked for the firm. At issue in the proceeding are certain disclosures that were made in PageOne's Form ADV, as well as conflicts of interest related to the business relationship with United Group of Funds. And I think it's important to keep in mind that we're also dealing with a very, very small number of clients at PageOne that were impacted by the allegations here. There were approximately only 15 clients out of approximately 1,800 clients that invested in the private funds that are at issue. So it was a very small part of PageOne's overall client base. And I think it's important also just to spend a minute reviewing the procedural history as to how this case came up for a petition for review. On August 16th, 2014, the Commission issued the order instituting proceedings in this case. And only 5 months later, in January 2015, the respondents agreed to settle part of the case and engage in this bifurcated process. And the respondents agreed with respect to the recitation of the facts in the consent order, which would be deemed to be true for purposes of this proceeding and the petition for review. And the Commission and the administrative law judge would determine what, if any, sanctions would be appropriate that were in addition to the consent. On the consent, the respondents had agreed to be censured. They agreed to a cease and desist order, and that was accepted by the Commission on March 10th of 2015. In April of the following month, the administrative law judge held a hearing with respect to what sanctions, if any, would be appropriate, and in June of 2015, the administrative law judge issued a decision, which is the one that we are filing our petition for review on. We feel that the decision by the administrative law judge should be vacated, and it was erroneous for several reasons. One is that we feel that the collateral bar for 5 years that was placed on Mr. Page was not in accordance with the Stedman statutory factors. And also we feel that it's a dramatic departure from Commission precedent in almost exactly the same circumstances on other advisors. And for similar reasons, we feel that the revocation of PageOne's registration as an advisor was also grossly disproportionate to the violations that were consented to and grossly disproportionate to sanctions that were imposed on other advisors in very similar conduct and other very similar factual scenarios. And we feel also that it was error for the administrative law judge to award approximately or a little over $2.1 million in disgorgement when the funds that are ordered to be disgorged were actually loans that were given to Mr. Page by United. These were evidenced by commercially reasonable promissory notes. United has actually filed litigation to collect on that money. So to categorize that money as either profits or ill-gotten gains is just simply not correct and not consistent with the evidence.
Could I just ask you a couple questions about that while you're on it? I mean, one, did your client make use of the, I guess it was what, $2.7 million payments made by the fund manager? And then I guess the second question is, can you cite us, to a case or maybe further elaborate on your argument that disgorgement would not be appropriate if there's either a third-party claim on those same monies, as I gather is the case in the litigation, although liability is being denied, or even if there was actually, a judgment to pay those monies, to a third party in these circumstances.
Oh, yes, Chairman White. I think there's several points that you raised. Number one is that there's a real risk here of a double enforcement in terms of a disgorgement award by the Commission, as well as an award that potentially could be issued in the state court litigation against Mr. Page. But I think even more fundamentally, it gets to the definition as to really what is disgorgement and what should be disgorged. Here, as the case is indicated in our brief, disgorgement is only appropriate for ill-gotten gains or profits. Here, the money that Mr. Page received is neither. It's a loan that has to be repaid. It's a loan that's documented by a promissory note. It was commercially reasonable terms. So to say that the funds are somehow ill-gotten gains really does not capture what disgorgement is entitled to do. And also, yes, to a certain extent, Mr. Page did spend some of the funds, but that doesn't negate the fact that these were not ill-gotten gains. These are funds that still have to be paid back to United and were evidenced by the promissory note. So we don't think that, and that the Division of Enforcement has not cited any cases that would support the argument that funds that were loaned to a person would be appropriate for disgorgement or be considered ill-gotten gains. So your
argument is basically that a loan can never be an appropriate candidate for disgorgement?
Yes, exactly, especially in these circumstances where the loan has been documented, the terms are reasonable, it's not an affiliated party, and that litigation's been instituted to collect on it.
Mr. Stein.
Just as a follow-up, does Mr. Page currently believe he's obligated to repay the loans to United Group, or is he taking the same position here as he is in the suit with United Group?
He is defending himself in the suit with respect to United. They filed a state court case. He's contesting that the money is owed because he had discussions with the founder of United that the loans would be forgiven in the event that his firm, Mr. Page's firm, was sold to United. So that transaction has not occurred, but it was not due to Mr. Page's fault. Mr. Uccellini, who is the owner of United, died in a plane crash, so the transaction could never be consummated. But the loans were essentially a form of earnest money deposits that were to be placed as a down payment for the sale of Mr. Page's firm.
So you're saying they're not loans in the other lawsuit?
Well, we're defending the loan. We're saying that the money on that case is not owed under the loan because there was another agreement with respect to the founder that the loans would not be pursued. Whether that's ultimately successful in the state court case is another question, but there still is the risk of a double exposure with respect to that.
So just as a fault, would the respondent be willing to escrow the amount of the disgorgement pending resolution of the dispute over the loans in state court if any future repayments were credited against the disgorgement? This would appear to address the concern about double payment.
Well, there's also the concern with respect to inability to pay, so the respondents have submitted the sworn financial statements with respect to the money, that the money's not there to put into escrow. That could be a possible solution in an appropriate case, but here the respondents simply don't have the money, as demonstrated with the financial statements that were put together by a CPA firm. The liabilities of both respondents far outweigh their assets, so the money's not available to put into escrow.
Okay, thank you.
So turning to the bars, essentially the revocation of PageOne's registration as an investment advisor is a death sentence for the firm. It's obviously no longer allowed to operate if that sanction was imposed on it and allowed to stand, and we feel that was erroneous. Also, the collateral bar that was placed on Mr. Page is also extremely draconian and not consistent with either the Stedman factors or commission precedent in other cases. And as a starting point, we noted in our briefing that the Court of Appeals has said that the Commission does have an obligation to be consistent in cases where there's similar facts and similar legal issues, and that there can't be a dramatic departure from Commission precedent without some sort of explanation or some sort of reason for why that departure was made. And here, the administrative law judge in the decision below did not address the relevant precedent, did not explain why he imposed such draconian sanctions, especially in light of the other findings that the administrative law judge made. Here, the initial decision by the administrative law judge acknowledged that the respondents' disclosure infractions were not the result of an intent to harm clients. The initial decision specifically found that Mr. Page did not ignore regulatory responsibilities. The initial decision credited Mr. Page with reliance on a nationally known compliance consulting firm that was helping to craft the disclosure language that's at issue. Mr. Page had an attorney working on the language. There was also an experienced in-house compliance officer that was working. And we acknowledge and certainly agree to, for purposes of the settlement, that the disclosures were flawed. But I think the reliance on the compliance consultant, the compliance officer, and the attorneys all indicate, with respect to Mr. Page's intentionality, a lack of intent to defraud people. And we think that finding is well supported with respect to those issues. And also, the administrative law judge found that he was impressed that Mr. Page did take responsibility for the flawed disclosures. He did that in a number of different ways. Number one, by agreeing to this process of the bifurcated settlement. He did agree to the allegations and the settlement that was agreed to. And Mr. Page also specifically and sincerely expressed remorse and responsibility for the conduct that's at issue here. So nevertheless, even with all those mitigating factors, the administrative law judge still imposed sanctions that were far outside the norm on Mr. Page and PageOne for the conduct that's at issue. We cited a number of cases in our briefs with respect to conduct that's similar decisions from the Commission that we feel is relevant. There was one case called Focus Point Solutions that's discussed in our brief. There's a Paradigm Capital Management, and Shelton Financial Group. These three were all Commission decisions that were settled, and none of those three decisions in any way imposed a revocation of the advisor's license. There was no suspension of the principals involved, and also the conduct at issue was very, very similar to what Mr. Page and PageOne were accused of, namely failures to disclose conflicts of interest that were very serious on the Form ADV, and also receipt of compensation from third parties that was not disclosed to investors. So the allegations are very similar. In the Department of Enforcement's brief, they try to distinguish those cases by saying, well, there's no scienter involved with the violations that were settled to in those three cases, but that's really a distinction that's not, doesn't make a difference, because it's really the Commission's obligation to look at the underlying conduct and the underlying facts of the case, and not to look specifically at what subsection of a particular statute was charged. In all three of those cases, the conduct was more egregious than what occurred here, and the sanctions were substantially less with respect to what was ultimately imposed. And significantly, in those three cases, the advisors were allowed to continue into business and did not have their advisory license revoked. There was also another case called the Vernaza case that was in the Ninth Circuit that's discussed in our brief. That case also involved a scienter violation, just like this one does here. And also that case, in contrast to this one, was fully litigated. Here, Mr. Page and PageOne did consent to the bifurcated process. And even in that case, when there were multiple misstatements in the Form ADV, in the client engagement letters, fully litigated, the only sanction with respect to a bar or a suspension was a 6-month suspension for the advisory firm as well as the principal. So we feel that the sanctions that were imposed were dramatically out of line with Commission precedent in this case, and there was no justification for that. Also, when we look at the Stedman factors, those two weigh against the sanctions that the initial decision imposed on Mr. Page and PageOne. In particular, several of the factors. The first is that whether the conduct is egregious or not. Here, the administrative law judge accurately found that the conduct, while there was flawed disclosures, was not particularly egregious in the sense that there was disclosures on the Form ADV that there was a business relationship with United, that compensation was being paid from United to PageOne and Mr. Page. And even though the disclosures, as Mr. Page acknowledged, were not accurate, and were flawed in hindsight, there still was some meaningful disclosure and attempts to craft the proper disclosure. This was a complicated transaction. Mr. Page was operating on a non-disclosure agreement with the purchasing entity, and there were several attempts to revise the language, working in conjunction with counsel and with the compliance consulting firm. And even though the disclosures were ultimately found to be flawed, as the initial decision found, they weren't particularly egregious. And the administrative law judge also found that and credited Mr. Page for his efforts in terms of relying on counsel and compliance consultants. Also, I think it's important to note that there was no finding in the initial decision that these investments were in any way unsuitable for the clients that invested in them. All the clients were properly accredited. They received a private placement memorandum that disclosed the risks of the investments, and we don't have any allegations that funds were misused or anything like that. Also, the conduct was isolated in the sense that it just involved this particular United Fund. This was the first time that PageOne had ever worked on a private offering. There's no likelihood of recurrence because PageOne is not engaging in these types of private placement activities anymore. And importantly, the respondents have recognized the wrongful nature of the conduct, accepted responsibility, and there's a very low likelihood that there would ever be a reoccurrence of the issues that occurred here, given Mr. Page's assurances and given the fact that he no longer works with private offerings. I think it's also worth noting that Mr. Page and PageOne stopped the conduct at issue about 2 years before the order instituting proceedings was issued, so on their own they took up the corrective action to address these problems. Thank you, and I appreciate the Commissioner's attention.
Thank you very much. Mr. Schmidt, do you wish to reserve time for rebuttal? Okay, very good. You may proceed.
Good morning, Commissioners. My name is Eric Schmidt, and I represent the Division of Enforcement. It's important to focus on what this appeal is about and what it is not about. Respondents agreed to a bifurcated settlement, which resulted in a consent order making findings and imposing sanctions. In the order, the Commission has already found that respondents committed fraud in violation of the anti-fraud provisions by recommending UGOC funds to PageOne investors while hiding critical information about obvious and extremely serious conflicts of interest. The undisclosed conflicts that have been found by the Commission are stark. Page agreed with UGOC to raise $20 million from PageOne clients for high risk in a liquid private real estate fund. And as a quid pro quo, UGOC agreed to pay up to $3 million to Page. The timing and amount of those payments to Page were tied to Page's ability to raise money for the funds. Thus, Page had an enormous personal stake in inducing his clients to invest in UGOC, and his failure to disclose this conflict was an egregious violation of his duty as an investment advisor. Now, the record reflects that clients would have considered this information highly material. One investor, Robert Tobia, who in October filed an action against Page and PageOne, submitted a declaration to the staff. That's Exhibit 99, Division Exhibit 99. He says in that declaration it was important to him to know about any conflicts of interest, and that before he personally asked Page if there were any potential conflicts in connection with the UGOC investment. And Page said nothing to him about his commitment to raise $20 million or to the fact that UGOC was making payments. Now, Page ultimately induced PageOne clients to invest over $15 million. And I submit that's the important 15 here, $15 million, not the fact that there were 15 clients that invested. And in a quid pro quo for that $15 million, he received $2.7 million from UGOC, which he has never repaid and which Page now claims to have spent. So the big losers here are likely to be PageOne clients, because one of the three funds has already collapsed, and a major investment in the other fund is bankrupt. So the only issue before the ALJ and now before the Commission is whether the public interest will be served by declining to impose any sanctions in addition to the censure and cease and desist order already imposed, or whether respondents' egregious failure to disclose known conflicts of interest warrant significant additional sanctions. The ALJ concluded that the public interest warranted additional sanctions, including a 5-year bar against Page, revocation of PageOne's registration, and joint and several disgorgement of $2.2 million plus interest. The ALJ did not award the full relief sought by the division, did not award civil penalties, and it gave respondents a $565,000 haircut to the disgorgement that the division sought.
Mr. Schmidt, just leaving aside the ability to pay, in your view, would a civil penalty be appropriate in light of the violations here? Could you sort of elaborate on that?
The division sought a civil penalty here, and we do believe it would have been appropriate to impose one given the seriousness of the conduct.
Did you have an amount that you sought, or you just sought
I don't think we sought a specific amount in our papers before the ALJ.
Okay, thank you.
So, Mr. Schmidt, while we're on sanctions, right, you sought revocation of registration and the bar, right?
Yes.
Section 203E of the Investment Advisors Act says that the Commission may censure or revoke registration, and 203F says we may censure or place limitations on the activities or suspend or bar. So given the plain language of the statute, which says or, not and the fact that in the order instituting proceedings, the Commission has already censured the respondents, doesn't that preclude the Commission from revoking registration and or opposing a bar?
I don't believe it does, and in fact, the Commission sent the ordered additional hearings to determine whether additional sanctions were appropriate in this case. So it seems to me that the Commission was certainly suggesting by doing that it was possible for the ALJ to award additional sanctions as set forth in the statute.
And if the Commission decides to move forward, would we need to then revoke the censure, given the plain language of the statute?
I don't know the answer to that. We certainly wouldn't have any objection to the censure being revoked if that was appropriate. Mr. Page argues that his conduct was not sufficiently egregious to justify a bar, but fraudulent conduct already found by the Commission and the ALJ is presumed to be sufficiently egregious to support a bar. And the Commission has stated, this is in the Scammell case, which we cited, page 17 of our brief, quote, ordinarily and in the absence of evidence to the contrary, it will be in the public interest to bar from participation in the securities industry a respondent enjoined from violating the anti-fraud provisions. Now, nothing about this particular case warrants making an exception from that general rule. Mr. Page claims that the bar would be inconsistent with Commission precedent, but the precedents he cites don't support his argument. Focus Point, Shelton Financial, and Paradigm Capital decisions were non-Sienter cases, and we submit that Sienter absolutely does matter when deciding whether or not to bar or what additional sanctions are appropriate. Pardon me. Focus Point and Shelton involved failures to disclose fees paid to advisors by a broker for back office support. And the Commission found that the arrangement should have been disclosed because it, quote, might have led the advisor to favor certain funds and lead to, quote, potentially conflicted investment advice. Paradigm involved an advisor entering into principal transactions with a related fund. And because of the relationship between the advisor and the fund, the advisor was found not to have provided effective notice or obtained effective consent to principal trades done on behalf of the client. The wrongdoing in those cases does not compare in severity to Page's recommendation that PageOne's clients invest in a high-risk and illiquid real estate fund while refusing to disclose his huge personal stake in having clients invest in those funds. Finally, respondents cite to the Commission's 2003 opinion in the Vernazza case, which we believe actually supports the imposition of a bar here. In Vernazza, the Commission imposed 6-month suspensions on advisors who had received only $75,000 in undisclosed compensation. In contrast, Page received $2.7 million in undisclosed compensation for recommending the UGOC funds. Now, Page seeks to minimize the seriousness of his actions by blaming his subordinates. Page claims that his wrongdoing consisted, quote, merely negligent or reckless reliance on his assistant, Sean Burke, and on consultants. But that's not what happened in this case. Page deliberately chose not to disclose conflicts of which he was aware. And in fact, the Commission has already found Page told Mr. Burke that, quote, he did not want to disclose the true nature of the arrangement with UGOC. So the performance of Burke and NRS, the consulting firm, is immaterial. It was Page who was conducting the negotiations with UGOC, and it was Page who was making the recommendations to PageOne clients that they invest in the UGO funds. And he sat down with them and made those recommendations and never told them that he had promised to raise $20 million from PageOne clients, or that he was receiving payments from UGOC. And this was not a mere oversight. The Commission has already found in paragraph 17 of the consent that Page refused to make full disclosure because, as he testified, quote, it's too dangerous. It would cause thousands of clients to get extremely nervous if I was selling my firm. And the Commission found that, quote, in other words, Page was concerned that the true nature of his interest in the fund manager and, in turn, the private funds he was recommending would be important information to investors. Now, the ALJ characterized this conduct as extreme recklessness. The division believes that the findings and the evidence of this case compel the conclusion that Page was not just reckless, but that he chose not to make full disclosure of known conflicts to advisory clients. But the extreme recklessness found by the ALJ is more than sufficient to support the relief that he imposed, including the bar with the right to reapply in 5 years. Respondents also argue that the disclosure of fictitious conflicts on PageOne's Form ADV, which the Commission has found were false and in violation of Section 207, somehow mitigates their failure to disclose actual conflicts. There's no support for the remarkable proposition that inventing fictitious conflicts cures a failure to fully and accurately disclose real conflicts, and the assertion is completely inconsistent with an advisor's duty not to lie to his clients and to disclose all actual and potential conflicts of interest. Second, it's important to note that during 12 months of the 2.5 years that PageOne investors invested in UGOC, PageOne's Form ADV had no disclosure at all about the UGOC funds. And during the time there was no disclosure, PageOne clients invested $6 million in the funds, and Page received $1 million in compensation from UGOC. The bar imposed by the ALJ would be supported by that conduct standing alone. As we stated in our brief, we believe the other Stedman factors support a bar here as well. This was not isolated. It was went over 2.5 years, involved numerous investors. There is a likelihood of recurrence if Mr. Page stays in the industry. He'll have many opportunities to violate the law again. And as we argue, we do not believe that blaming your subordinates is an honest recognition of one's own wrongdoing.
Mr. Schmidt, there's no Investment Company Act bar, right, in this as part of the remedies?
That's correct.
Why is that?
That's actually one of the reasons we appealed, is that we don't really know why the ALJ did not award relief under the Investment Company Act. We believe he made the findings necessary to support such a decision, and one of the things we're asking in our cross appeal is that the Commission award appropriate relief under the Investment Company Act.
So your view is that if we were to find the industry bar appropriate, that is a sufficient finding for the Investment Company Act?
Yes.
I mean, in all the facts and circumstances?
Exactly. Now, just to touch on disgorgement, the fact that the ALJ chose not to award penalties due to Mr. Page's financial condition doesn't mean that he also has to forego disgorgement. In fact, we think in this case it'd create a perverse incentive for violators to spend their ill-gotten gains quickly and without restraint, and I'm quoting the ALJ, if they were allowed to avoid disgorgement by simply spending all the money and all their ill-gotten gains. The $2.7 million paid to Mr. Page is clearly ill-gotten gains. He received that money, he spent it. UGOC demanded three years ago that he repay that. He's not repaid any of it. And I think, as your questions pointed out, Mr. Page is trying to have it both ways. He's arguing before the Commission that because UGOC is seeking repayment of the notes, that he's entitled to avoid disgorgement, whereas on the other hand, when in the action by UGOC, he's claiming that he doesn't have to pay under the notes. Whatever happens with his litigation with UGOC, the fact is, sitting here today, he's got he's received $2.7 million. He hasn't paid any of it back, and there's no guarantee that he will ever pay any of it back.
Mr. Schmidt, why shouldn't the respondents be entitled to actually retain the amount of the fees they actually did disclose?
The fees that they did disclose?
Yeah, or the basis on which they might receive fees in the ADV?
There's no evidence in the record that they didn't retain that money, and in fact, that wasn't an offset against the disgorgement. I mean, I'd like to turn now to the cross appeal. The ALJ imposed a 5-year time-limited bar rather than a permanent bar with a right to reapply after 5 years. And the division submits that the form used by the ALJ is not authorized by Investment Advisors Act 203F, and we have appealed to correct what we view as a technical error. Section 203F permits the Commission either to suspend for a period not exceeding 12 months or bar a person from being associated with an investment advisor. And the distinction is that a suspension terminates under its own terms, and that after the time limit is run out, the suspended person is no longer barred from association. A bar is permanent, and a person who's barred can only associate with the consent of the Commission. And the consent is obtained through the reapplication process, which, contrary to the respondent's assertion, shows that 203F does in fact contemplate permanent bars with a right to reapply, because the right to reapply is how you get to the consent that's actually referred to in the statute. Requiring barred persons to obtain Commission consent before reassociating is an important safeguard. It permits the Commission to satisfy itself that association by past violators is in the public interest, and Commission consents are generally limited to association with a specific entity under specific conditions, which can provide important investor protections. Respondents argue that the 5-year suspension ordered by the ALJ is authorized by the power granted to place limitations on the activities of an associated person. As we say in our brief, we don't think that's a fair reading. It would render superfluous the reference to suspensions and bars in that statute, and it also is inconsistent with the structure of the law, which lists sanctions in ascending order of severity, and so we don't believe that it's appropriate to read that power into the power to place limitations on activities. I have nothing more. If there are any... Oh, my time's up.
Thank you. Mr. Haim, you may present your rebuttal.
Thank you. The Division of Enforcement was making the argument that Mr. Page had been unjustly enriched by the $2.1 million that was received from United. But in actuality, in terms of the context of this transaction, what was happening was that assets were leaving PageOne Financial Group and going over to United. And this was the important background and context for this transaction. The $2.1 million that United was paying to PageOne was designed to compensate PageOne for the lost income that was going to be the result of assets coming out of PageOne and going into United. So over the course of 7 years, the money that was negotiated and agreed to as a down payment, it was essentially kind of a guarantee as part of the sale to United that this money, this loans to Mr. Page, was designed to offset the loss of advisory fees that PageOne would suffer as a result of money that was being placed from United to PageOne. So the $2.1 million that we're talking about here is not any sort of gain to Mr. Page. It's really meant as compensation for the lost income that was going to be the result of the assets coming out of his firm and going over to the private funds. With respect to the other point that was made by the Division of Enforcement, there was discussion with Mr. Tabaya, one of the investors, and I would note that that person was never called at the hearing, was not given the opportunity to cross-examine, so I would respectfully request that no weight be given to any of those statements with respect to that investor. Through the brief, the Division of Enforcement continues to miscategorize Mr. Page's testimony as the disclosures were being too dangerous. That quote is taken out of context. What Mr. Page was discussing was respect to there was a danger to him in light of potentially violating his non-disclosure agreement with United of being sued or being held responsible if disclosures were made that were not correct or that disclosed confidential information. So the division's use of that term, too dangerous, is taken out of context and twisted with respect to how it's used in the brief. And the other 2 points that the division made seem to imply that the commission should just automatically bar Mr. Page or revoke PageOne's registration because he consented to a violation of a fraud provision and that there was a future risk of violating the law merely because there was a fraud consent order here. That's not the case. We submit that the commission has responsibility to weigh the facts and circumstances of each case and to give substantial consideration to the mitigating factors that the administrative law judge finds with respect to reliance on counsel, reliance on the nationally known compliance firm, and the other steps that Mr. Page took to try to remedy these deficiencies. Thank you very much.
Thank you very much. Mr.
I have one quick question. You said that this was the $2.1 million was compensation for lost income from assets going over to the firm, but it also seemed to be tied to raising money, into this real estate fund. Can you please try to harmonize those two statements for me?
Yes, I think with respect to the point about how the division argued that they were somehow tied in together with raising money for United was tied into the payments that Mr. Page received, but that the evidence doesn't support that. Mr. Page was not aware of where United was drawing money from in terms of paying the money that was the subject of the loan and the earnest money deposit. So we don't think there's any argument or basis to say that United was tied into somehow using money that Mr. Page was raising to fund the money that was paid, the $2.1 million. Really what happened as part of the negotiation, Mr. Page was giving up assets, and PageOne had assets that they were getting annual management fees on, and for 7 years, that was the negotiated term, that was the loss of the income to PageOne, and that's what the $2.1 million represents.
So what assets were given up?
The money, so the investors, the 15 investors that are at issue here that invested in United, the money that they used to invest in those funds came from their accounts at PageOne. So there was a decrease in their balances at PageOne representing the money that was invested in the United funds.
Okay, thank you.
Thank you.
Anything else? Okay. Thank you very much, Mr. Haim. Mr. Schmidt, you may present your rebuttal.
The points that Mr. Haim just made are all inconsistent with the facts that have already been found in this case. His description of the too dangerous language is inconsistent with the finding of the court that, or of the commission that language actually referred to his concern about the understanding of PageOne investors who were investing in the funds, not his concern about running afoul of a non-disclosure agreement. And I think that's set forth clearly in the order. The assertion that the $2.7 million that was paid to him, and it wasn't 2.2 or 2.1, it was 2.7. He got a haircut from the ALJ, that was somehow compensation for lost advisory fees. There's no evidence, in fact, that that's the case. And it's not true that every investor moved money out of pre-existing PageOne investments. Some investors put their money into PageOne because they were solicited to invest in PageOne, not because, so, you know, there's really no evidence supporting the tie that Mr. Haim just referred to. Also, I'd point out that Mr. Haim claims that there's no evidence that the timing and the amount of UGOC's payments were tied to Page's ability to pay money. But again, that language comes right out of the consent at paragraph 10C. These are issues that are not, open to litigation anymore. That was part of the settled consent order, and those facts exist for the purposes of this proceeding. Thank you.
Okay. Thank you very much. Mr. Haim, Mr. Schmidt, thank you for your participation. The commission will take this matter under advisement, and we stand adjourned.